at Mercatus Center at George Mason University. And we're a fairly large research organization. We're not a think tank, they're very clear about that. We're affiliated with the university, which we pride ourselves on. And we've got, most of the other scholars are PhD economists. I'm one of 3 or 4 lawyers there. So our focus is largely economic, reducing regulations that harm consumers, competition, and generally trusted markets to allocate capital resources. But my focus is telecommunications. I do a lot of work with the FCC, so broadcast, cable, broadband, spectrum policy, and yeah, that's me.
Kate, but actually before you begin, how many of you guys were here last year? All right. So if you remember last year, one of our speakers almost didn't make it because he had just had a baby the night before. So in keeping with that tradition, Kate now has a 3-day-old.
Thank you. So yes, my name is Kate and I have a 3-day-old. And I haven't slept in 5 days. So yeah, So if things feel a little hairy up here, please forgive me for that. So my name is Kate Oakley. I am a Senior Legislative Counsel at the Human Rights Campaign. The Human Rights Campaign is the nation's largest organization working for lesbian, gay, bisexual, and transgender equality. We have over 1.5 million members and supporters. If you've seen people, or if you have yourself, or if you've seen people change their Facebook logo to the red sign that they equal, that's us. That's our special marriage equality one. The rest of the time we're blue and yellow, which I actually almost came in New Jersey College today and then backed off. And so as Senior Legislative Counsel, we have a legal team that does a lot of different work. We have people who do federal work, work on legislation at the federal level, and also a lot of administrative advocacy at the federal level. I myself work primarily at the state and the local level, and I think we're going to talk more about exactly what that entails, but it's pretty great.
All right, and Zac.
I'm Zac Morgan. I'm a staff attorney for the Center for Competitive Politics, and you all just heard what I think about 2 specific laws in Utah, Missouri. I'm an attorney for the Center, which, despite being called the Center for Competitive Politics, has a website at campaignfreedom.org, and which is odd and very frustrating when we have to put that on briefs. Basically, we're the nation's largest organization dedicated to protecting and defending the political rights of the First Amendment of speech, petition, and assembly. To that extent, our litigation team represents pro bono clients, does amicus work, testifies in front of administrative agencies, and so on and so forth.
All right. So let's first talk about where you guys practice, specifically who you practiced before. So where do you do most of your advocacy? Is it before an agency, before courts? Please tell me about that. Brent.
Sure. So I have, Mercatus is a unique place, I think. I mean, we probably all think our organizations are unique, but we straddle, Superior. We straddle the line between a university and kind of think tank policy world, and we try to keep our foot in both. And much so, I have multiple audiences in my view. So much of it is the FCC. I filed public interest statements before the FCC about why regulations should be repealed or added, or what policy they should see. But I've briefed members of Congress on issues, on telecommunications issues, spectrum issues, and also the public sometimes when telecom makes a lot of people sleepy. It's pretty boring when they hear about it, but there are some issues, like a few months ago, the FCC worked on repealing rules, the sports blackout rules, which if you're a sports fan, you're familiar with these, where they black out certain regions of the country. The FCC repealed these, and I was in favor of that repeal, and did some op-eds, explaining to people why these rules are in place and why it's time to remove them. So I have multiple audiences. I also do law review pieces, some economic. When I co-author with an economist, we'll do economics journals. So a small part of our audience is also other academics.
For me, I sort of have 2 different ways of approaching this. So internally, I'm on our policy team, and so it's my job to advise our policy team about what kinds of laws we can support, can't support, what kinds of changes would need to be made in order for us to be able to give our support, and helping them, go through those stages. Externally, I think it's fair to think of me as a lobbyist. I work primarily with state legislators and city councilors across the country, as well as with other LGBT groups who are on the ground organizing, and they may need the benefit of city council. But so for me, externally, my work is really very directly with the lawmakers, and internally, I am advising our team about what laws we can and can't support.
I'm relatively boring in most city litigation work. So essentially, we mostly do most of our practice in the federal courts. We currently have 8 active federal cases. And one of the reasons I apologize for how disjointed I am, we have 2 arguments next week in front of the 10th. Originally, the 10th actually wanted them to both be on the same day on 2 different cases. We did tell the clerk's office that was an actual physics problem. And so I do apologize for that. But yes, so essentially that's what we do. Is we generally are representing clients. I also have written law review articles and as well as some other publications on the side as a general way of either talking about cases or where we think things ought to go in the states or at the federal level. But for the most part, most of what I do is relatively directly through litigation.
All right, so litigation in the public forum before state legislatures. What are some of the more unique challenges to advocating before these forums?
So I guess before the FCC, the biggest legal issue is probably ex parte rules, where if you're briefing a commissioner's office, you have to, in the past, for decades past, a lot of negotiations went on out of the public eye, and so now there are rules that whatever you discuss with commissioners and their staff has to be publicly revealed, so that other parties, just out of fairness, other parties can know what their opponents or friends are saying to commissioners. So that's probably the largest legal issue. I think in the policy world you have a lot of freedom to, you don't just have to say what the law is, you can say what it ought to be, which, as I said, it's freeing, and I can expound on what I think is the optimal policy.
Yeah, I think in terms of the challenges of the state legislatures, and I think it also holds true for the cities, when we're working on non-discrimination laws, which is the vast majority of the legislative work that I do, we're doing that against a backdrop of existing discrimination laws and other civil rights laws. So we're talking about the way all of these different things intersect. One of the amazing things that has been happening in our field is that the Equal Employment Opportunity Commission at the federal level has recently meaning the last, 3 years, really changed its stance on anti-LGBT discrimination. I'm not going to go into this too much right now, but at the federal level, there is currently no, the Civil Rights Act does not include sexual orientation and gender identity. And so there is no federal law that explicitly prohibits discrimination on the basis of being lesbian, gay, bisexual, or transgender. And that's something that my organization is working really hard to fix at the federal level, at the state level, and at the city level. But one of the great things that the EEOC has done in the last couple of years is that they've really expanded the way that they think of sex stereotyping discrimination. So for those of you who may be familiar with the PricewaterhouseCoopers case, the case is talking about sex stereotyping. Now the EEOC includes discrimination on the basis of gender identity as under their sex stereotyping analysis, and they just recently, I think 3 months ago, extended that to sexual orientation as well. And that's great news. So here's the challenge. The challenge is that we need to make sure we're being honest in our talking points, and we now really can't say anymore that there's no law at the federal level that protects LGBT people, even though there really isn't one that talks about us explicitly. And so we have to figure out how to message that not only when we're talking about our federal work, but also if we go into a state that doesn't have non-discrimination laws, either at all or on the basis of sexual orientation and gender identity, try and make sure that they understand why they still have to do that, even though they perceive that the federal government has already done that. So that's one challenge, which is both frustrating and really great.
Great, Zach.
So there is one thing is just as a procedural matter. We have a multi-jurisdictional practice, which inevitably ends up meaning that I've read the rules of virtually every circuit court of appeals in the country, and they're all very, very different. For instance, the Third Circuit and the 10th Circuit require you to actually do a virus check on your PDF before you submit it through Pacer, which I think is probably a legacy of some clerk in 1995 on Usenet discovered what computer viruses were, told the judge, and the judge freaked out. But that is the way we get to do the 3rd and the 10th. In the DC Circuit, you can't use PASM, the Latin for we have cited this so many times we shouldn't have to put the number of pages that we've cited it on. So I'm a campaign finance attorney. We cite the case Buckley against Vallejo quite a bit. So in the DC Circuit, you have to go through and count the pages. That's 1, 2, 3, 4, 6, 10, 12, and so on. So there is a lot of the procedural work, which is really important, especially since we are coming in not just as attorneys with actual clients, but we are trying to shape the law. And we go into courts that are not the jurisdiction in which we're licensed to practice in. And so we're going on a proactive HAO with local counsel. We want to be entirely respectful of those courts and entirely respectful of local jurisdiction. And for instance, we brought a case in district court in Delaware, and I'd like to think that had we been barred in Delaware, been licensed in Delaware, we would have brought that case exactly the same way. And I think that's just tremendously important because you want to show respect to the jurisdiction that you're in. It just is one of the other challenges, of course, is that our clients are also often advocates, especially in what I do, which our clients are often politically minded individuals with a specific focus. So one of the things you have to tell them is when we know you talk to the media. When you talk to the media, there are some things you can't say. You can't break privilege. I don't want you to inadvertently say things that would make it so that you break attorney-client privilege. I don't want you hiding things from me before I put things into court filings simply because you think that might be a bad fact. Because Rule 3.3 is a real thing for me as a Virginia attorney. So it's sort of like the Kevin McCarthy, Francis Underwood thing, like vote your conscience, vote your district, just don't surprise me. And that is something that we have to do sometimes with our clients because they're advocates and they're just as zealous in their causes as we are in ours. But you have to sometimes explain that no, this is somewhat different because we're in front of a treadmill.
All right, so then, you're doing policy work, Zach, you're doing a lot of litigation work, but you guys are all lawyers. So how do you balance this appropriate relationship between being a lawyer and then being a policy advocate?
For me, I don't have clients, so that removes a lot of complication. My client is the public, if that. They didn't ask me, but they are. Right. So a lot of that tension is not present for me. I see myself more as an educator and more as a legal historian, especially with telecommunications laws that date back to the 19-teens in some cases. The sports blackout rule I mentioned is from the 70s, and it predated before there was copyrights for TV broadcasts. So there's been a lot of law changes in the interim. So when I'm arguing for repeal or sunset of a particular regulation, it's like a Jenga tower in that there's all these intervening rules, regulations that you also have to account for because in some cases you move something here and it can collapse in some other area. So this requires a lot of legal history. There's a lot you have to learn when you're doing this. Get back to the question. There's not too much tension for me. I try to represent the public and consumers and taxpayers to the best of my ability, and I'm largely an educator in that role.
Yeah, I like that line. I represent the public, but nobody really asked me. Because I think it's really important. And so for me, in my job description says that my client is our national field team. So our field team is the team that we have that goes out and organizes. They do the grassroots organizing, and they go out and they try to get laws passed. And so my client, technically speaking, is the national field director. And I'm telling him these are laws that we can support, these are laws that we can't support. And in my advice to him, what I'm saying is, these are the laws that we can support because they are in the best interest of the LGBT community, and these are the ones we can't support because they're not in the best interest of the LGBT community. So in a very sort of direct sense, he is my client, but in a much more sort of holistic sense, it is the entire LGBT community who is my client. And again, they didn't ask me. And I think that it's really important, particularly when you're doing this kind of identity-based lobbying, that you're really cognizant of the fact that you are representing people who may not see issues in the same way, or experience issues in the same way that you do, right? So I myself am a member of the LGBT community. I have experienced discrimination as a member of the LGBT community, and that is not the only way, and my experiences are not the only kinds of experiences that a person who's discriminated against for being LGBT that they may have. And so it's really important that I constantly come back and say to myself, am I truly representing the best interests of everybody, not just of this white woman, middle class, fairly young, white and cisgender white woman, right? Like, so it can't just be the kind of discrimination that I personally experience. And it can be really hard because a lot of people who do LGBT-related advocacy are ourselves LGBT. We come to it from a personal place. And then, so you've got this personal element of it, but it's not about you. It's about everybody. And so I do think that there's this tension there. You know, my organization does its best to represent everybody in the LGBT community, and I can tell you that there are people in the LGBT community who do not feel represented by us. So we have to continue to always make sure that we're checking in and we're doing our best to truly represent everybody, which is a challenge.
And Zach, how do you balance, and especially being the litigator of the group, how do you balance between the law and advocacy part of your organization?
Sure. And also, I'm pleased as a member of the public, I have attorney-client relationships with both these two individuals. Well, again, so one of the things that is somewhat nice about my office, there was a period of time in which we were smaller than we currently were, and I was running the Twitter account, which wasn't very funny or very good. So we do have a communications team. We do have an individual who goes into the states and tracks that kind of legislation. So fortunately, a lot of that doesn't end up falling upon me, which is nice in the sense that I get to be shielded, that our litigation department, as a result, gets to be shielded from a lot of the quote-unquote politics of what we end up doing. So again, with us, the question is making sure that when we're litigating, that we're not falling all over ourselves because of the cause, and we're maintaining that what we're doing is in the best interest of the client. If that means admitting and that intermediate scrutiny might apply to a regulation that a client is challenging, that means that we do that. If I didn't have a client, I would be shouting up and down from the rooftops that everything has to have strict scrutiny. You can't regulate these sorts of things. This is association, goddammit. The First Amendment is absolute. It says Congress shall make no law. What the hell? But we can't do that because the world wasn't created ex nihilo last Tuesday. So I think that's the most important part, is making sure that as an advocate, as somebody who believes very strongly in the things that you're doing, that when you're in court, you remember that you have duties to the client, to the tribunal, to the bar, and that you fulfill all of those. To the extent that the conceit of this panel is that being a policy advocacy attorney is different from being an attorney, when you have clients, that I just don't simply think that's true.
All right, thank you all. And so let's now talk about more of the nuts and bolts of what you do. Starting out, who sets the direction for your work? Do you set it yourself? Do you have to respond to a board of directors or something like that? Or is it just you have a big goal and you go off and do what you can?
For me, it's more the latter. We have a board, actually. It's our board meeting today, which I came from. But they're fairly hands-off. I mean, we have a cause in mind, general cause, and there's a lot of, I have a lot of freedom to pick which projects I want to do, and it's nice. So I mean, within that, my area is pretty specialized. So if you don't want oversight, pick a specialized area that no one understands, and you can get that. But so we have a team. We have 3 scholars working on the tech policy area, and work full-time on tech policy. We also contract out with scholars at universities to write. But no, within that I have a lot of freedom. I discuss, we have a team kind of goal that we want that fits within the larger mission of the organization. But I have a lot of freedom to pick my projects, where I think I can have the most effect. I mean, you have to pick your battles, and so.
Just a follow-up question to that. You have the larger organization. Have you ever had a situation when you needed guidance from someone higher up to say, where should we take this?
Our team, they give each team a lot of freedom within that. So, you know, aside from my immediate boss, who you know, and we discuss things. No, I haven't had conflict with the organization. I mean, there's a lot of trust, especially in you know, public policy where you're working for causes. I mean, there's a big filter for certain people, and so they know where I'm coming from, and you know, we certainly philosophically align often. So there's a lot of trust that I'm doing. You know, I'm working in the interest of the organization. We also, I guess one thing that does keep us in line, our white papers, our law review articles, or economic papers we send out for peer review with other universities. So we certainly can't get off the rails too much. But no, it's a great organization. I have a lot of freedom to pick my projects.
Okay, how about you?
Yeah, I mean, it's a great question. So we do have a board, including a public policy committee, and in terms of endorsements and some other very high-level policy decisions, the public policy committee makes recommendations to the board. That said, the policy work is driven by the staff, and you know, I think it's interesting because there is a fairly small population of people and an even smaller population of attorneys who are working in this field. You know, I'm really fortunate to work for an organization that is fairly well funded, and so we have a fairly big staff. But you know, organizations out there who want to be doing LGBT work, and not everybody has the real capacity to dedicate full-time staff, and certainly not a full-time attorney, or as many full-time attorneys as they need to do the work. So it's interesting because I think we have a small community of attorneys, both at HRC and in our allied organizations, and we work very closely. And I would say that's sort of our peer review process, right? So if I have a question about something, I talk it over with my boss, and you know, we are like, well, we're just sort of on the fence about this. This is what we prefer, but we think we could live with this. I'm going to go call someone at the ACLU, right? And then we're just going to check in with our friends and make sure that if we're in a gray area, that we're in a gray area that, to the extent possible, and it's not always possible, but to the extent possible, that other people who we respect who are doing the work are in the same general place that we are. And if they're not, then we have conversations about it. And that's something that I really value, is that even though the people at the other organizations, while our organizations may have their own conflicts sort of in a meta way, the people all get along really well. So that's really great because we have those resources. I would also say, to sort of Melissa's point or question, that my boss is really tremendous. She's been my boss for on and off for 7 years. And she's been a mentor, she's been a teacher, and she really believes that that it's the legal expertise is the place that the organization should be going to in terms of making these policy decisions, right? We're a policy organization, and we need to make sure that every single piece of legislation we work on has an attorney assigned to it, that nothing goes forward, not a press release, not a blog post, not an endorsement, nothing without an attorney's eyes on it. And she's been a huge advocate for that. And so I would just recommend to any of you in this room to find someone who will go to bat for you, and to the extent that that's someone who is in your current organization, to really allow that to happen. Because I know for me, it's meant that I've had a lot of independence to do the kind of work that I want to do and to learn about areas that I'm interested in but am not an expert in. And rather than just stick my neck out and potentially do it wrong, that I've been allowed to really develop my skills before I get there. So, for my 2 cents on that.
All right, and Zac, who sets your direction?
That would be our legal director, Alan Dickerson, who's also a great person and a mentor and a friend. Alan actually and his wife did a reading of Much Ado About Nothing at my wedding. Yeah, the part of that, how do you suffer love for me thing, my wife picked that out, so I'm not really sure what that means. But in all seriousness, so we do have a board, there's a president, there's a chairman, there are processes by which things are approved, but for the most part, Alan has a lot of authority over what the litigation department does. And so what this means is sometimes we can be somewhat strategic in how we think, and sometimes we simply can't. For instance, we recently got sucked into, as you may have heard me grousing about when I didn't know the mic was on, about this case in Missouri, where an individual was sort of hauled in front of an administrative agency, told that he was a lobbyist. We don't happen to think he was. We think the statute's against that, and the evidence they presented was, the commission presented was poor, but of course I have to believe that because I'm his lawyer. But And I do actually think that's true. And so we ended up getting parachuting into Jefferson City on about 2 weeks' notice, which is another one of the things that's interesting about being a policy advocacy attorney, is that sometimes people will recommend cases to you, and that's what happened in this instance. A friend of the organization came and said, you might be interested in helping this individual. And so we had to learn Missouri state law and the Missouri Administrative Procedure Act on relatively short notice. And that is one of the challenges that's also quite fun about the job, is that, again, this goes into multi-jurisdictional practice, is that we learn a lot about how various different state agencies operate, about how you have to practice in front of them, about the different rules, and you also can you end up inadvertently comparing and contrasting between the two, and you sort of understand how diverse the federal system is.
Can I actually add more?
Of course.
Please.
One of the things I think that I really love about my job is that sometimes I'll go in the morning and have no idea what it is I'm going to be doing. I usually have a plan, and the plan is often thrown out before my first meeting in the morning. And that's because when you're doing legislative work, we can have our long-term strategy, we can have our dockets, we can have everything all organized and beautiful. And then this past legislative season, we were fighting off over 120 anti-LGBT bills that were introduced across the country in state legislatures. So with the understanding that the marriage equality case was coming up in the summer, in the spring, the very end of the winter, early spring, the state legislatures just erupted with anti-LGBT legislation. And so while I had plans for what I was going to be doing from January till June, I did none of those things. And instead, the entire team was focused on beating back that bill. So when you're talking about setting an agenda, we certainly have our own internal agenda. We have the agenda that we have built with our partners, and then we also have to just live in the reality of the legislative system. So sometimes you're going to get something 2 weeks before the vote, and you're going to have to figure out what's happening. And sometimes your entire day or weeks or months the agenda for that time is completely set by people who not only do not know, but you probably don't really like.
I'll second that. Some of our work is reactive. You're reacting to news, to legislation, to regulations, especially in tech policy. I don't focus on it as much, but one of my colleagues does really cutting edge stuff, Bitcoin, drones. I work in internet policy. The FCC right now is trying to bring some old TV regulations onto the internet, which some of this is reactive, and so that's another reason why we don't have too much structure in what I'll go after. Some of our other teams, if they do federal budget or healthcare or education, they certainly have, I think, a little more direction on what their main priorities are. But with tech, where these issues are coming up constantly, and states and federal government are trying to figure out what to do with these. I mean, Uber is another one. A lot of it is, trying to stop, slow down. Let's think about this, and it's somewhat reactive.
Yeah. And adding to that, too, one of the other things that even since I do more litigation, we have so many cases going on all at once, is that sometimes you'll have a case that's completely set, filed, done, whatever, and then you wait for the court decision to come down. And when that happens, everything goes from 0 to 60, and that depending on what court you're in, that could be several months. So all of a sudden, there's this case we haven't been thinking about for the last 7.5 months. It turns out the Third Circuit just issued a 17-page opinion, completely reversing the district court, who had written a perfectly wonderful opinion in favor of my client. And all of a sudden, we're having to petition for rehearing en banc, trying to get the mandate stayed, contemplating whether or not we're having a petition for cert. And that just is a 0 to 60 thing that happens, even with stuff you have already put in motion. Once things are in the hands of the judiciary, obviously the judiciary can sometimes have its own mind.
So, all three of you have said a lot of your work tends to be reactive. So what are some of the hurdles that you face when you're facing reactive work? Is it an uphill battle?
Well, I had on my docket, when I went home for Christmas, I had 6 bills that were pro-LGBT, inclusive bills that were on my legislative agenda for this year. Not a single one of them made it past the committee. It was not that year. We didn't have a good legislative year this year. We did have some bills that passed, but none of them were mine. I'm trying not to take that personally. But then we had this slew of 120 bad bills, and I think it's hard enough when you have a good bill, you have a relationship with the sponsor, you have a relationship with, you've been developing relationships. There's one bill I've been working on literally the entire time I've been at the Human Rights Campaign. Every year I show up at the state capitol and I lobby, I know everybody, right? And every year we're like, well, we'll see how, we always have to vote count, we'll see if it ever comes to the floor, and we're doing all of that stuff. And it takes years and years to build the kind of momentum that you need to make sure that you're getting all of the people who need to be in the room together, That's for a good bill. When it's a bad bill, you don't get a heads up from the sponsor, right? No one's introducing a bill that will allow county clerks to opt out of performing marriage licenses for same-sex couples. They're not calling the Human Rights Campaign and being like, by the way, we're introducing this at noon, right? And so we're trying to then, we have to find out about it, we have to submit testimony, we have to mobilize our members, we have to, if we can, get somebody local, we have to arrange for people to get out there and to testify about why this kind of bill is harmful. We have to try to shut it down. And so, you may have heard this past spring we had the Religious Freedom Restoration Act that was in Indiana. We had these other, that's one category of these bad bills that we saw this year. And in Indiana, that one happened to pick up speed, but we saw them in many places around the country. And any of you remember hearing all this backlash about Indiana and how Eli Lilly was speaking out against it, Angie's List spoke out against it. Angie's List is based in Indianapolis, and they said that they were now no longer going to be expanding in Indiana. Lots of different Salesforce, NCAA, lots of different organizations said, look, Indiana, if you pass this law that will allow businesses to refuse service to same-sex couples or people who are LGBT, that we're not going to continue operating in Indiana. That's not acceptable. Well, so that groundswell took literally months, right? And it takes a long time, and when these things are just getting thrown through, you don't have notice, it's so difficult to make sure that you can get all of the pieces that need to be engaged in time to make a difference. And we actually saw in the beginning of the legislative season, we didn't have as much success beating things, because it took us a while to get people to understand how outrageous the stuff was that was happening. I mean, Religious Freedom Restoration Act sounds great. President Obama voted for it. President Clinton signed it at the federal level in the 90s, right? And we supported it in the 90s. And so to try to explain to folks why it was acceptable in the 90s and it's not acceptable now, and to message about Hobby Lobby, about religious restrictions, about marriage equality, and trying to do all of our education about who LGBT people are, at the same time that we also have to educate them about the Religious Freedom Restoration Act from the 1990s. Wow, we've totally lost people's attention. So trying to get all of that together in time to beat things is really hard. And so we found as the legislative season went on, we were much more successful in defeating the bad bills. Of those 120, only 6 passed. So that's a really big deal. But the ones that passed away because it took us a while to get that momentum. So that's one of the really great things. And you can't just call the sponsor and be like, this is terrible, kill it. They know it's terrible. That's why they introduced it. So it's hard to sort of get to do all of the things that we do when it's a bad bill. We can't get an entree in that same way.
Well,
Zac,
and even if you, and even when you have, even when it's our case. So for instance, and since you're doing CLE credit, I'll do a very brief primer of how campaign finance law operates in terms of getting things into the court, and I'm sure you're all so excited. So in order to bring a case against a party, the Bipartisan Campaign Reform Act, you have to file the case under 52 U.S.C. 31000 note. It's actually note. It is not its own statute. It's basically footnote 5, but it's not numbered. Thank you, United States Code. And what you have to do is you have to ask for, you go to a single judge and you say, hi, we have a challenge to the Bipartisan Campaign Reform Act. We believe that this part as applied is unconstitutional, and that single judge has no authority to hear the merits. What that judge does is says it has been foreclosed by the Supreme Court. If it has not been foreclosed by the Supreme Court, you go to a 3-judge panel, the district court, and you get an automatic appeal to the U.S. Supreme Court from there, which is how, for instance, the McCutcheon case, which was brought in 2012, was heard so rapidly with resolution in 2014. Unfortunately, the Federal Election Commission, who are the defendants in our cases where we bring paper challenges, obviously, seems to believe that there are no possible new challenges to the Bipartisan Gambling Reform Act. And they're a creature of statute and they have to defend the law. So you will end up, or at least we have in one of our cases, Independence Institute versus FEC. We had several rounds of briefing on the question of, first we asked for a preliminary injunction because it was close to an election. Our client wanted to do specific activity. In this case, running a 30-second ad encouraging 2 United States senators, one of whom happened to be up for re-election, which is what the trigger was on the FICRA, and asking them to sign on to the Justice Safety Valve Act, a piece of criminal justice reform legislation that had been introduced by Senator Paul. And that they weren't advocating good for or against either of these people. They couldn't in any event for at least one of the individuals because that senator wasn't up for re-election. But again, this triggers FICRA. So we suggested that maybe as applied, FICRA should cover this type of speech. This is really issue speech. It's not the kind of thing that FICRA was trying to regulate. And the FEC said, no, we think this is foreclosed by Citizens United. So after doing preliminary injunction briefing, we then had to brief in front of the judge on the question of whether or not we got a pre-judge court. The district judge agreed with the FEC, so Citizens United did in fact foreclose our challenge. And so now we're up on appeal, not actually on the merits, but still on whether or not we get our pre-judge court that we want to get and have to get by statute. So just the simple fact of the matter is that sometimes the statutory framework that you're dealing with, even when you have a case that you're bringing that you think you might have some sort of element of control over, doesn't in fact control, because there are going to be roadblocks towards gaining sort of resolution and litigation.
So for my part, the reactive part, I mean, for me, I like a balance of doing, some reaction things, which, for me, the past year, if you've heard of net neutrality, that's been in the news a lot for the past year, and I have concerns about it. The internet has been largely unregulated for a couple decades, and the FCC is now trying to regulate them more or less like internet service providers, more or less like phone companies, and this was a hot topic issue. It was on John Oliver and a bunch of news shows. It's kind of nice working on this issue because it's in the news, it gets me interviews, it gets me on radio. But on the other hand, it's kind of grueling, and it's a lot of people have said all they've wanted to say for the last 10 years on this issue, and I don't feel I'm adding that much. But so I try to find those issues that haven't been discussed. And so that's one side. So the reactive part, it's kind of fun. It gets you in the news, and on the other side, but it's also unfortunately somewhat partisan now, which is not good when you're trying to change minds. On the other side, I just put out a paper that I've been working on for a year about federal spectrum. Federal agencies have a lot of wireless spectrum, and there is some. This is not very partisan. So actually, a Democratic commissioner asked me to talk about my paper. She liked my paper a few weeks ago, and there is room to work, on both sides on this. And that's a long-term thing. I mean, no reporter's going to call me up and discuss, the intricacies of federal spectrum law and auctions.
That's a BuzzFeed article, absolutely.
Yeah, it's statistical. But that's a long-term thing, and I do foresee it having some larger impacts on what scholars do and what the FCC does, and so it's a balance.
All right. Moving in a different direction, Kate, Brent, you guys mentioned that you have somewhat of an educator role at times, and Zac, I would imagine you educate tribunals in your role. So how often do you find yourself in this educational role, and how do you balance the fact that you're going to be an educator, but also you all are licensed attorneys and you have obligations under the ethical rules as licensed attorneys? Brent, you want to start?
Yeah, I mean, I do see my role, as I said, largely as an educator, as a legal historian, because a lot of the rules and regulations I'm dealing with are decades old. There's a lot of history people have to get up to speed on to understand the effects of particular regulation or repeal of particular regulation. So yeah, I don't see too much tension there. I don't have clients, and that's freeing in some ways. So yeah.
Yeah, I mean, I think in my position, being an educator and being a lawyer are very intertwined. I think from an ethical perspective, there's sort of two main things that I worry about. One is what I alluded to before, which is that I that I am not LGB and T. And you know, people across in our community have a range of experiences, and so I am acting as an ally, not as a person with that shared identity a lot of the time. And so I have to make sure that when I'm speaking as an ally, that I'm doing so in a way that is respectful and productive, and then I'm also constantly checking in and making sure that that I'm doing that in a way that people find to be appropriate. So there's that element of it. The other thing is that I work really closely with LGBT advocates on the ground. So as a national organization, we have a certain entree into some conversations. But hey, if you are working in a state, we'll say Missouri, or you're talking about Missouri, right? They have a really strong state LGBT group there with whom we have a pretty nice relationship. And so sometimes what I'm going to be doing is not going to a legislator in Missouri and saying, hey, this is the rights of ideas you should do. What I may be doing is going to the state organization and saying, look, this is our 2 cents. What do you guys think? And if we can come to, if we end up agreeing on what the outcomes are, then we can provide some level of support. But the point there being that if I go into a meeting with the executive director of that organization, who is incredibly smart and talented and politically connected, that he is not an attorney and I am an attorney, and that when I go in and say this is the state of the law, people are going to listen to that in a way that they will not listen to him. Even though he is older than me, he is local, he is very connected, he will be able to have more sort of capital in some parts of the conversation, but when I'm saying this is not the state of the law right now, I'm doing it as an attorney. And so, you know, that sort of fits within the ethical, the ethical constraints, but I mean, I think that it's just something that I'm really thoughtful about, which is, you know, if you're going to come out and represent that you know the state of the law, that you're an attorney, you have to not be wrong when you do that. It's important. And that people do listen to you. I mean, you really do get a different kind of cachet when you go in, and so you have to make sure that you're being responsible about that.
I like that. You cannot be wrong.
You can't be wrong.
Yeah.
It's really a bad idea if you're wrong.
Good advice just across the board.
Try not to be wrong. If you take anything home today, I hope that's it.
Zach, right?
As somebody who has had to do this, there's nothing more embarrassing than having to put into a footnote in federal court that, yes, opposing counsel was in fact correct. That case did not stand for the principle, which was cited for in our opening brief. We apologize to the tribunal for the error. That's incredibly embarrassing, and you never want to do that. But of course, you do have to correct your mistakes and represent the law faithfully to the tribunal. It turned out to not be a problem. There was another case that did stand for that proposition. When it comes to education, which I think was what the initial question was, I do think that even when you're doing in a litigation-focused shop, as we have, there are ways in which we can educate both the public as well as tribunals and agencies. I mean, obviously, first, there is strategic litigation, and along with strategic litigation, there is, and of course, our media folks handle a lot of this, telling other people about what our cases are about and getting that message out to the public. And fortunately, we have been fortunate enough that some of our cases have gotten some national and local media attention, and that's very important. For instance, we have this case in Delaware that I've alluded to a number of times, and the Wilmington News Journal editorial board does not like our case very much. But what they have done is they have permitted us to write letters to the editor responding to their op-eds, allowing us to present our side of that case, and I think that's useful. Another thing that you can do is we have done some Freedom of Information Act requests. We're currently actually in front of the Judge Moss of the District Court of DC on, we're seeking a first general counsel's report. I am not stuttering. That is what the Federal Election Commission claimed it was, because they have regulations where they have to disclose their first general counsel's report, and we asked for one that they intentionally had withheld. And they said, no, this is the first general counsel's report, also invoked a bunch of privileges under FOIA. So if we do happen to get that document, and we are ultimately successful, that can be useful for education as well, because what we think that document might suggest is sort of how the FEC has considered in the past, as opposed to possibly how it is considering now, the major purpose requirement for how you become a political action committee, which is extraordinarily important, especially for organizations out in the ether on all sides of the aisle that are 501c4 organizations and are trying very, very hard not to accidentally trigger PAC registration at the federal level. And of course, there's also regulatory comments, which we do, we have done. One of the things that the FEC did a couple of years ago, actually, that was incredibly nice, and that I do say positive things about the FEC, was that they asked sort of for a catch-all from the regulating community. They said, what is it we should advocate for? Do you think we should be changing any of our internal structures? Should we be publishing internal guidelines and documents? And we were able to submit, a 15 to 20 page. This is what we would like the FEC to do. It was nice to know that the commission was willing to listen to the regulated community and those who advocate on behalf of the regulated community. And that was nice to be able to have that exchange with the commission.
So I'm going to move on to some ethical issues. And my first question is actually directed right at Zach. It's something that you had written in your outline that is part of the materials, where it was something like, don't get caught up in advocating for the cause when you have a client issue. Or am I saying that correctly?
That's I'm vice counsel and invoking my Fifth Amendment right. Now, sorry, that made me kind of feel like I'm out of Senate hearing with these. So yes, not that I would ever suggest that I have personally ever gotten carried away in the spirit of the cause, but I think this is an actual thing, and I've seen this happen with a lot of public interest shops. I mean, litigation is exhausting. Right now, we have, especially again in our practice, we are filing an appeal from an administrative agency today, at some point today, in a state. We have a DC Circuit reply next week. We have the 2 arguments in the 10th Circuit, which the 10th Circuit was at least kind enough to put on 2 different days after we pointed out the physics problem. And in the midst of that exhaustion, it's easy to fall back on, and in the midst of this whirlwind of a storm, it's really easy to fall back on sort of your talking points. And to just suggest that, well, this is the way the law ought to be, and get angry at the other side because the other side disagrees with you, and this is the 3rd brief from the FEC that you've been reading in 3 different cases, and the FEC is so clearly wrong, how could they not know that? And that is something you have to check because you are a lawyer and you are an attorney. And if, in fact, as somebody who's involved in the policy advocacy world, especially coming from my perspective, where this is an 85-15 issue and all the laws are against us, we're on the 15. You have to remember that if the law was the way you wanted it to be, you probably wouldn't have a job. And so you have to be cautious and you have to be careful. You have to remember that you're slowly trying to move the ball forward as much as you can, and that you have clients and that you have all these things that go along with that. Again, I mean, I really do think that the most important word in the policy advocacy attorney part of the panel is the attorney part, and that you have to maintain all of your requirements to the bar. I mean, especially when it comes to disclosing bad case law. The 3.3 CA3, I think, is the Virginia Professional Conduct Guidelines rule. It is very, very easy to try to hide the ball, and I've seen other attorneys do this. They've taken cases in ways which I personally wouldn't have, or shaded them. And I'm not saying these are people on any side of the ball or even on my issue, but I have seen this in briefs that are filed by policy shops. And you want to be very, very careful to be completely and entirely upfront with the tribunal about precisely what those cases stand for. If the case is bad for you, you have to admit that, especially if it's in jurisdiction. I know I sound like I'm just, yes, this is professional conduct. We've all taken the MPRE, Zach, how could you think that? But it does happen when it's very easy to fall back on, well, the case law obviously must mean what I think it means because I know the truth.
All right.
And can I actually add to that as well?
Of course.
So for me, it's a little different. I'm not a litigator, right? We work very closely with the other organizations that do litigation. And these are some of the people that we call, right? When we're not sure about, we're in a gray area, can we accept this, can we not? Call a litigator, right? And if they say, oh my God, please don't do that, you will undermine these 5 cases that we have filed, like, great, glad I asked, right? So we work very closely, we work very closely with these litigators, but we're not litigators. But I'll tell you sort of my corollary to that is that, how many of you have heard about Kim Davis in Kentucky, the clerk who's refusing to, right? So what's really challenging sometimes about our work is that our opponents are often not only wrong, in my opinion, and hopefully in the opinion of many people, but they can be really aggressive, they can be really outrageous, and it can be very difficult to maintain professional decorum when you're on the opposite side of a table from somebody who's arguing a position, for example, like Kim Davis's. We found a lot of times that the person who's having that conversation can make a big difference, but it can be really challenging as an attorney to be in this position where you're just looking at something, you're like, you are so wrong. You are so wrong. Your understanding of the case law is wrong. Your understanding of the Constitution is warped and weird. And I'm not speaking about Kim Davis specifically, but just generally speaking, right? And I think there are lots of places in which the Constitution, reasonable people can differ about what exactly is there, and you can have these conversations in the lawsuits and go up to the Supreme Court and get interpretations and come back. Like, that's all part of the process. sometimes you really see opponents who are chosen for their ability to be, or elevated, who are chosen for their ability to be outrageous. And that can be really difficult because people get a pulpit to talk about how they've been horribly discriminated against by the LGBT community. And so it's hard sometimes to maintain your professional decorum when you're trying to have a conversation with someone who's not only coming from a different place from you in terms of the legal argument, but a completely different place from you in terms of the morals at stake, the principles at stake. And you can't just look at somebody and be like, hey, you're a huge bigot, right? That's not a productive conversation, and it's not part of your role as an attorney to be labeling people in that kind of way. But sometimes your eyes just get like, what am I supposed to do? And so that can be really challenging. And it's easy to get frustrated, but what you're trying to do as an educator, right? Because that's part of my job. What you're trying to do as an educator is move the ball forward. Sometimes you have to engage. Sometimes you don't engage. There's a cake bakery that has become famous recently because they refused to do a wedding cake for a gay couple. They claim that they have a First Amendment right to not do that. I would point out that case is still under litigation. I would point out that this same cake bakery does wedding cakes for dogs, which is not a thing I even use. I love my dogs. I've never heard of a dog wedding. Apparently, not only are there dog weddings, but this particular cake bakery has no difficulty making a cake for a dog wedding, but we're not doing it for and those people are now on tour, making, I would assume, some significant amount of money going around the country talking about how they're being persecuted by the LGBT, the radical homosexual organizations like mine. So, it's challenging to sometimes be there. And I was recently at a city council meeting. I had gone and provided testimony about a non-discrimination ordinance that they were considering, what other cities had done, what the benefits would be, what some of the important things for them to think about, and then went to the follow-up city council meeting, and the first 5 people who testified were opponents who mentioned me by name and mentioned that I worked at a radical homosexual organization, which is, believe it or not how we bill ourselves. And like it gets personal, right? These people have my address. And so I think it's, there is that element of it, right? Where I mentioned that it's personal and it's also professional, and it's really sometimes hard to keep that wall up and to say, as a professional, I can't engage with these people, but I need to engage with them only in a way, to the extent that I do need to engage them, I have to do that in a way that moves the ball forward, and is consistent with my obligations as an attorney, and also my obligations as an educator and a representative for the community.
If can I jump on that just real briefly? And yeah, no, that's absolutely correct. And I think that is one of the things that you just have to be aware of is the audience that you're speaking to. For instance, in litigation, the audience is the judge, not the opposing counsel, is so very deeply wrong. And while if I was doing a series of blog posts or if I was in a Twitter fight with the FEC, there are ways that things might be phrased. You can't do that with when you're in litigation. You want to be careful and cautious and sober because, first of all, this is a general practicing matter. Every federal judge is smarter than you. Every single one. And you're going to have, and they're very sharp, they're very quick, they're going to understand the issues, their clerk's going to understand the issues, things are going to be brought up, and then you're going to be able to engage with them in a oral argument, or at least my boss will actually. And one of the things that I love about litigation, this entire process of filing the complaint, of briefing, of getting in front of the federal judge, is that I think the federal courtroom is probably the last place in America where the long-form argument matters. And that's a wonderful, wonderful thing, and it's a great way to be able to advocate for causes, and without having to be in a situation where where the rest of the world seems to think it's easier to advance the cause by yelling insults or finding out people's addresses as opposed to letting it know.
So Brent, do you have anything to add?
Sure. I mean, I guess one issue we get, and I think a lot of research institutions and think tanks get, is everyone wants you to do research for them. So. Members of Congress.
By the way,
do research. Industry wants us to do research. We're not a Congressional Research Service. We don't do that for members of Congress. We're not a consultant. We don't do paid research. Fortunately, we're mostly funded by foundations and individuals, so we have we have the ability to say no, we don't do that. But, you know, that tension's always there in other groups. Yeah, I mean, there's consultants, there's think tank, and there's a whole spectrum of people who do that work. And, you know, I like to think we're on the more academic side where we have independence, and, you know, and just maintaining that credibility is a big issue. I mean, you do get close to regulators and companies, and you have to, you know, keep them at arm's length. You're not always their friend. And, you know, I do take some comfort in that even though I'll agree with a company or a regulator on this issue, I'll disagree with them on several others. And so I think that keeps me in check.
All right, so let's move on to start wrapping things up. You guys are all so passionate about what you're doing, and I feel like I know the answer to this question, but would you recommend that someone go into the public policy field?
Not against me.
Hey.
Yeah, absolutely. I mean, this isn't something that I necessarily had set out to do when I went to law school, and it was something that you know, I really came to find that it truly gets me up in the morning. And so there are some days where it's really hard. We were talking about adrenaline rushes, right? So I was pretty much living on one adrenaline rush that began in January and ended in June. So that's exhausting, right? But it also is really exciting. And so, you know, I think I would recommend to you, if you want to go into public policy, that you choose something that really matters to you. And, you know, it's part of my service. I work for 501c3/501c4, and I don't give the organization a lot of money unlike other people. And so this is my contribution to the cause, and it's also pays my bills, which is really nice.
Yeah, I agree. I mean, it's not for everybody. Don't get me wrong, but and I went into law school as well, thinking I'd do something else. You know, I mean, like antitrust law, but when you look at my resume, it's all policy. I don't know why I was fighting it, and that's where I ended up. And I think employees can often sniff that out when you're interviewing with places, and it goes the other way. If you're trying to get public policy and you're not, you know, a true believer, they'll sniff that out as well. But yeah, I recommend it. I mean, if you know, it's not for everyone, but for me, it's been great. I love my job. I hope to be at Mercatus for a while.
I can give a serious answer too, if you'd like.
Sure.
No, it's an incredibly rewarding thing. I didn't go to law school to do what I do either. Technically speaking, my degree comes with a concentration because George Mason University School of Law gives that national security work. I wanted to sit on the 5th floor of the Department of Justice to do this work. I'm much happier doing what I am doing now, I think. But no, it is truly one of the most rewarding things you can do, especially when you're doing things where you're actually, where you are helping folks. I mean, not in a life or death or in the sense of granting civil rights to individuals. And well, the First Amendment is a civil right. I think you understand what I mean. Yes, we say that a lot actually. But it was really, we had a client in Colorado. This PhD, along with a friend of hers who actually writes Harry Potter and moral philosophy books. That is his niche. They wrote a 35-page policy paper advocating for abortion rights. And at the very end of this 35-page paper, which discussed the nationwide movement on personhood, what was going on in their state, the effects of this proposed state constitutional amendment, and what this would mean for women who miscarried, they said to their end, and if you support what we're saying here, if you believe in the predicates in which we put forward, you should probably not support this constitutional amendment, which I think is something they probably could have gleaned out of the fact they, you know, had 200 and some odd endnotes in this 35 pages and 20,000 words. And the state of Colorado said, well, we think you're a PAC. You need to give every time you mail that out, we need to know what UPS store you went to, where you bought stamps, and how you did that. And that case is on appeal in front of the 10th. When we did get a win in district court, and it was really, really gratifying to see how happy our client was.
All right, so we have time for maybe a question or two from the audience, if there are any. Anyone? You?
I'd like to know, like, a book that, not necessarily a legal one, you guys think would be good for someone who might be interested in public policy.
Well, here's a slightly different answer to that question. I have copies of the Municipal Equality Index, of which I am the founding author, which I highly recommend. I have some copies, and I'll have to send it to you. I mean, I think, I don't know. I really like to read, not necessarily policy books, but books about the issue. So I recently read a book that's written by the mother of a transgender daughter, who really really changed the way that I thought about advocacy for a person like her, being a mother. Her philosophy was, I'm not an LGBT advocate. I had no dog in this fight. My child was suicidal and wanted to die. And the only way that I could help my child not kill himself was to learn about this and to learn what I had to do. And so it's a different approach to the issues than mine. But I think, you hear stories like that and it enriches your ability to go forward and do what you do. So that's my non-answer to your question.
That's a good answer.
I also don't necessarily know there's a policy book. Bill, I mean, I would recommend, obviously, not just to you, but to everybody, Unfree Speech by Bradley A. Smith, who is the chairman of the Center for Competitive Politics. It actually is a very, very good book. Brad was the commissioner on the FEC. It was planned by President Clinton in 1999. And he sort of walks through the history of campaign finance up until the year 2000. So if you read the book and then you're outraged, and then you can read the Bipartisan Campaign Reform Act, then maybe you'll want to consider supporting the Center for Competitive Politics. But I would suggest that. And just generally speaking, I think whatever passion you might have, I think reading and learning more about it is always important, because what you read becomes the furniture of the mind, and obviously, and I think that's always useful when you're advocate.
I think we're struggling to find a good book because, I suspect, our trajectory is very different. There's not much you can generalize from each of us. I heard from a friend, at a happy hour in law school about Mercatus looking for an RA. 3 years later, that turned into a job. I don't know how you could, write a book.
Once again, alcohol saves Western civilization.
Yeah. But as far as working public policy, I think a lot of it is so public policy organizations don't do a lot of recruitment generally. So a lot of it is just checking in, if they have a position open, and funding situations change often. So the answer might be no 1 month, and 2 months later they got a big check from a foundation or something, and they'll have positions. So some of that is just persistence. In law school, I worked at the FCC for 10 months, and they rejected me the first summer because summer's very competitive. They get all the Ivy League kids, but I was at George Mason, so I worked there in the winter, and it turned out to be a great experience and led me to where I am today.
That's the exact same thing that happened to me. I applied to HRC as a law fellow for the summer, and I didn't get it because of all of the Ivy League kids. I was local, so I got to go during the semester. I went 1 semester, they asked me back for a 2nd semester, then they asked me back for a 3rd semester, then they asked me back for a 4th semester, and then I got offered a job. So, to some extent, you really do have to be persistent, you have to be creative. I will also say that I worked in private practice for a little while, and I totally agree that they can sniff out who's a public policy person and who's not. That's definitely there. I ended up working in a practice that was family law practice, so they weren't doing public policy per se, but the partner in the firm really, one of his major plans was the Democratic Party. His values were very aligned with my values. I was very upfront with him that when I came, I wanted to be doing LGBT family law, and he was he was going to let me expand that practice. And so there's a way, I think, to do policy work in litigation, and obviously there's a place for litigation as policy work, and I would recommend to any of you who are doing firm work or litigation work and who have an interest in public policy to just be persistent and looking for things, because funding absolutely does change, and I don't think I would be as good at my job now if I hadn't spent all that time doing divorce mediation. No, in all seriousness, you have 2 people across the table who absolutely loathe each other and have children and have to figure out a way to work together. And if those people can figure out how to come up with a child custody plan that's going to work for them years before they can go their separate ways after cheating and lying and embezzling and God knows what else, then there's no reason you can't get city council to work together. And I think, you just have to have that kind of, having that kind of background and that kind of perspective, I think helps. And so I do think that you can sniff somebody out, but you should also make sure that you can talk about cross-training and that you've gotten stronger at doing something that you love by doing something that's similar to different.
All right. I want to thank you all for your time. It's lunchtime, so I think a lot of people are getting a little hungry. But yeah, Zac, Kate, Brent, thank you both, all 3 of you, so much for your time, for this very insightful panel. And so yeah, let's all move on.